Brian Crawford.
Here.
Leonard Knapp.
Here.
Robert Meir.
Here.
Howard Faree.
Here.
Sabrina Richardson.
Here.
Eula Simeon.
Here.
Jared Rickey.
Here.
Lenore Feeney.
Here.
And Jason Hammond.
Here. I'd like to ask for a moment of silence. Begin with the Pledge of Allegiance. Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Do we have any requests to address the commission for matters on the agenda? I did not receive it. Move on to the business meeting. Just 1 second. So that's fine. I just wanted to make sure I wasn't moving something. So we need to fix the floor. Yes. Okay. You're right. We have a motion for consideration of the minutes.
So moved. Second.
All right, just any discussion, I do want to call attention that I think there's a typographical error on the minutes under 6-1. It makes reference to an April 8th, 2021 minutes being approved. I think it was a May 13th, 2021 meeting. So if you'll accept the friendly amendment, then we will move to accept the minutes with that correction.
So moved as amended.
Any other discussion? All in favor?
Aye.
Any opposed? Guys? Item number 2 under the business is status update from the Department of Public Safety and Corrections, Office of State Police regarding the department's response to House Concurrent Resolution 4 of the 2021 regular legislative session. Good morning. Even though we all know you, go ahead and identify yourself for the record.
Good morning, Mr. Chairman, members. Lieutenant Colonel Doug Kane, Louisiana State Police Chief Staff. I provided to Jason, hopefully he shared it with you, a small brief on our response to HCR 84, item by item. Would you like me to go through that in brief, or just answer questions?
Now, why don't you, so for the benefit of everybody that's here.
All right, there were 10 items contained in HCR 84. The first 2 are outside of the purview of state police and in your hands as it relates to investigative timelines. So I'll start with number 3, which requires sustained complaints regarding a law enforcement officer to remain in the officer's file for at least 10 years. We retain sustained investigations for the entirety of someone's career, so we do not purge investigative case files. After a person separates from the agency, it's actually archived. So we have long held that practice of retaining investigative files.
And there's no anticipation of changing that rule in the near future?
No, sir. No, sir. Number 4, prohibit the use of chokeholds and carotid holds except when the officer reasonably believes he or another person is at risk of great bodily harm or when deadly force is authorized. And you should have the policy in front of you that outlines that prohibition clearly through the general policy guideline, a definition of a chokehold, and a prohibition unless deadly force is justified. Number 5, prohibit the use of no-knock warrants under certain circumstances. In talking to our SWAT personnel when this came out, they had made a tactical change years ago from no-knock warrants to an actual surround and call-out. So that's the practice that they utilize. Personally witnessed it Saturday night with the shooting of our trooper and surrounding the suspect's house. They engaged that practice of surround and call-out over the course of several hours trying to make contact with the suspect. And as you see, there is also, it's clearly identified in criminal procedure, so we normally don't duplicate in our policy what is clear in law. Number 6, adopt a policy to require any governmental entity that employs a peace officer to implement an in-service anti-bias training program as administered by Post. We contracted earlier this year with Fair and Impartial Policing, which conducted an implicit bias training for commanders, inclusive of the ranks from captain all the way to the superintendent. We participated in that training ourselves, and additionally they did a train the trainer for our training personnel, who then subsequently trained the remaining commissioned force. And as of this date, we're approximately 75% complete with training all of our commissioned personnel on implicit bias training based on the standards of fair and impartial policing. We did have to cancel 7 classes due to the COVID surge and hurricane, so we continue, and we believe we'll be at 100% prior to the end of this calendar year.
And what is the frequency that will be done? Is it planned frequency?
We will continue to implement that into our in-service training annually. We take those high point items and reinforce it through updated standards, best practices, or any new case law that comes out that is provided to our troopers annually. Number 7, adopt a policy to require any law enforcement automobile equipped with a dash camera that has technology to automatically record upon the activation of the automobile's police emergency lights to utilize that technology. And you should have the policy in front of you. It clearly details the requirements for not only in-car cameras but body-worn cameras, which relates to number 8 on HCR 84. Now go to number 9. To adopt a policy to require all enforcement agencies, correctional agencies, and institutions to disclose to prosecutors any and all information that may be used to impeach the credibility of prosecution witnesses, including but not limited to prior statements, prior criminal acts, or other misconducts. This has long been a practice of our Office of Legal Affairs. As we receive requests from the courts, that research is done and that information is provided to the requesting party. In addition, we took the liberty back in March 9th, 21, disseminated a memo out of my office that outlined all of our obligations as an agency and individually with regards to Brady and Giglio. Number 10, adopt a policy.
For those who may not be as familiar with Brady and Giglio, just kind of briefly explain what you're talking about.
So if officers, and this is layman, I will defer to my attorney if she wants to speak more, but basically if there is indications of false statements or credibility issues that come to light in a police officer's career, we have to reveal that to the court so that they have it in the course of their judicial process. And then finally, number 10, Mr. Chairman, is to adopt a policy to provide for penalties for noncompliance with post-reporting requirements. This has been done, continues to be done. There was an act passed that provides for civil penalties by Representative Bacala, which is now in statute. Subsequently, we went above and beyond, working with Post. We noticed that on the form for a employment status change to a law enforcement officer, there was no place to designate or identify to a reader that there is supplemental information. For instance, if somebody was under investigation, during the course of that investigation, they retired from the agency. All the block is retired, so if somebody else is looking to hire that officer, it just indicates that he's retired. So we work with Post to add a block that says supplemental information attached, which tells the reader or reviewer that there's more information that you need to dig into as it relates to this person. Post agreed with that, added this to the form, and it's now officially part of this Post form. And Mr. Chairman, if I may, briefly, as you know, Colonel Davis has been superintendent for about 11 months. We have worked hard to change the culture of our agency, improve processes, policies, training, operations, and HCR for us was just one step. We've gone well above and beyond, and I have some talking points to that I can highlight briefly to give you a perspective of what other reforms we have initiated within the department over the course of 11 months. We implemented a duty to intervene policy. That was always certainly part of our philosophy, but we codified it in policy. Subsequently, we're following up with that duty to intervene policy with a training program called ABLE, Active Bystandership for Law Enforcement. It actually grew out of a program in New Orleans PD called EPIC. So we are in the process of working with ABLE to meet all the requirements to launch that program. And that will be an ongoing training program with our department. And I have some basic information I can leave with Jason or send to you all so you can see what exactly ABLE entails. Enhanced
If you
accountability.
don't mind, would you leave it with the executive director, and we're asking to forward that to.
I sure will. Enhanced accountability with the body-worn camera policy, we've addressed that. Expanded use of force policy, we did not only address chokeholds in our policy, but we banned the use of impact weapons to the head or neck area. We also mandated all of our troopers to carry a less than lethal option. So they must carry a less than lethal tool on their belt in the course of their duties so that they have that option to use in a less than lethal encounter. Mandated implicit bias training, which we've discussed. Duty to intervene training program, ABLE, which we discussed. We are working to create a force investigative unit. This will be a specialized unit that will answer to the superintendent, that will investigate all use of force encounters and custody deaths by Louisiana State troopers or DPS officers. It's in the early stages. We promoted a captain a couple of weeks ago, so he's in place. We have subsequent positions that will build out, and then this program will be based on national best practices. They will be subject matter experts in investigations, and we're excited about that force investigative unit coming online. One of the things that we've struggled with in this department, and I'm sure you've heard it before, is technology. We have finally got some traction in that endeavor with the reports management system, computer-aided dispatch, e-crash, e-citation coming online, and what we are trying to do is build out these technologies and these solutions to really help not only us at the leadership level, but all of our supervisors and troopers in scene reports, scene dashboard analytics to help hold ourselves accountable and get a better idea of what is going on in the department and where our shortcomings are. So really leveraging technology solutions to better our agency. As far as reporting, we talked about the post-council report. We also have standardized our early identification system reporting. So if a trooper gets in a pursuit, a use of force, gets a complaint, those things are tracked, and once you reach a threshold, it tells the supervisor you need to look into this. Well, one troop is doing it on a spreadsheet, and this troop has file cabinets. We've standardized that across the board with a single spreadsheet, and we are continuing to build out an electronic capability in that computer-aided dispatch report management system to have a early identification system built in there so that we can pull real-time analytics and better visibility. But in the short term, we have standardized that system. Recruiting, I've sat at this table before and talked about our recruiting efforts. Mental health, we continue to promote and expand our Trooper and Employee Assistance Program. We've we've had some real success stories with this. We actually deployed the team during Hurricane Ida. And as you know, many of our employees were significantly impacted, their families were impacted. And we deployed our team members across 3 different troop areas to touch our employees, to check their mental health, their well-being, their families, so that they could focus on the mission at hand, and that was supporting our communities that were affected by the storm. Accountability, continue to act swiftly with regards to investigative needs, whether it's excessive use of force or other allegations. Continue to communicate expectations through vision and policy, enforce standards equitably and fairly, and transparency. And we're going to do a better job, as we have, communicating to the public. We are also, as part of that force investigative unit, they are going to work with our public affairs section to develop critical incident briefings after a use of force incident. You may have seen this in other agencies across the country, where when they can and it's safe to do so, they actually show video that indicates what happened in the situation, so that the public and the citizens we serve can see firsthand some level of what happened in that incident. So that's a continuing part of our force investigative unit build out. So with that, Mr. Chairman, members, I will rest and answer any questions you may have.
Any of the commissioners have any questions or comments?
Chairman, I do. In regards to
Commissioner.
the, thank you. Next year should be a new testing requirement. So this maybe is already in place or going to be in place, but I ask that the 2022 tests reflect a demonstration of understanding of these new policies and a practical application of the policies, reforms, and recent training. If they're getting the training, which we are at in service, and if it's being added to the policies, and as important as it is, and in fact it's new, I want to make sure that these new policies and new practices and reforms are in the testing, so we can, so that the employee can show a knowledge base of it, and we can judge their performance based off of their ability to practically apply it. So just want to put that out there before we start to plan 2022.
Absolutely.
Anybody else? I think that's it. Thank you for your presentation. The next item on the agenda is consideration of a request from the Office of State Police for reinstatement of 2,304.19 hours of sick leave with State Police Master Trooper Harold Williams per State Police Commission Rule 11.21.1. And I understand we have a representative here to discuss this. Could you identify yourself, please, ma'am?
My name is Susan Hudson. I'm here representing workers' comp at the Department of Public Safety.
You can sit or stand, whatever you're more comfortable. So, do you have any comments on this?
My biggest comment is that as soon as this is reinstated, he intends to retire.
Now, when I was going over it, it was late last night, so my math may have been off, but it looked to me like the calculations were off by 40 hours.
That was the reimbursement of 33, 44, 119 hours. Is that correct? That's was reimbursed. And then I reinstated 1,040 hours under my authority.
And it's actually, if we did it up to the date that he settled, it would actually be more hours. So the request is less than.
Well, actually, I thought it was 40 hours too short. I didn't think it was 40 hours too much.
Oh, no, it's,
So, yeah, Mr. Chairman, in my initial preview, in my initial authority letter, I advised that the approval going to the commission would be 2264.
Right.
19. However, for the agenda item, we amended it up to 2304.
I was looking at the letter, I wasn't looking at the agenda.
Okay, no, it was corrected on the agenda, yes, sir.
Okay, well, great. Like I said, it was late last night, I can only look at one thing.
The agenda is correct.
Okay.
And the severity of Master Trooper Williams' injuries and the accident that caused his injury sustained his extensive leave.
Well, and that's why I wanted to make sure he wasn't shorted for you. Correct.
Yeah, Mr. Chairman, if I may, we just want to go on record as the department certainly support this. It was a very tragic and scary incident when he was struck, and he's had a long recovery, and we wish him the best. I know he plans to retire and will continue his recovery, but we certainly want to be on record supporting Master Trooper Williams' request.
Do we have a motion?
I would so move.
Moved by Commissioner Knapp, second by Commissioner Ray. Any discussion? All in favor?
Aye.
Any opposed? Looks like the ayes have it. Thank you. In the matter of William R. Woodward, Department of Public Safety and Corrections, Office of State Police, docket number 21251-RV. Good morning.
Good morning, Commissioner. Adam Karamanis here on behalf of Trooper Woodward.
I'm sorry, I missed your name.
Adam Karamanis, Karamanis.
Good morning, Michelle Gerard on behalf of the Department of Public Safety, Office of State Police.
Just to be sure, no witnesses were subpoenaed for this hearing. Mr. Karamanis, do you have any witnesses that you intend to call?
No, ma'am, I don't.
And Ms. Gerard?
We have some stipulations. It's really the documents that are relevant to the appeal before you that we're going to introduce. I do have a witness here that I can call, or if the commissioners have any questions for him, we can tender him for questions regarding the two documents we're going to submit.
Why don't you go through the stipulations?
The first stipulation we have is to a document which is 2 pages. I've labeled it as J1. It's a receipt that's signed by Master Trooper William Woodward dated March 31st, 2021, and attached to it is a letter dated March 31st, 2021, addressed to Trooper Williams that is the notification that he's the subject of an administrative investigation. The second document is J2. It is a letter dated March 29th, 2021, addressed to Colonel Davis and others from Captain Eric Quinker, Troop F Commander, and that document outlines a deed of the IRS that Trooper Woodward made on March 24th, 2021, with attached documentation, and that document is 5 pages. With that, I'd like to introduce and file into the record J1 and J2.
Which of those documents were provided to Trooper Woodward at the time that he was provided notice?
J1, that is the notification letter in the receipt that shows that he got it. And I have copies for the commissioner.
So the joint exhibits are admitted into evidence.
Any
Wait
other
till everybody gets a
stipulations?
hold of theirs before we do. We'll just wait till everybody gets theirs. So.
So as the commission likely recalls, the reason we're here today is because Trooper Woodward received an insufficient notice of the investigation that he was the target of. When we last left off, the commission put the question forward, well, what did the state police know? Well, as you can see right now from J2, it should be page 3, the letter from Captain Cuenca to IA requesting an IA investigation in no uncertain terms provided that they were requesting that investigation because of what Trooper Woodward, how he operated the intoxilizer and how he documented the results thereof from the DWI arrest. Now, State Police has maintained that the notice provides sufficient allegation of the facts that he's being investigated for, but that's simply not true. I don't want to repeat what we've already gone over, but the policy they cite is so impossibly broad that it's impossible for anyone to receive that notice and have any idea of the actual substance of the factual allegations that are being made against them. And more importantly, this evidence shows that State Police had that information on hand. They could have easily provided that information, and they chose not to do so. And I want to be clear what we're seeking here today. We're not here challenging Mr. Woodward's discipline. He received a letter of reprimand as a result of this investigation. What we're here today seeking is a ruling from this commission that any notice that any other trooper receives from here on out that fails to sufficiently detail the facts of the allegations being made against that trooper does not pass muster. It's not valid. The State Police has to be held accountable. They have to follow the laws that this commission established and is tasked with enforcing. These laws are there to secure and protect these troopers' due process rights. A trooper cannot enter these interrogations having no idea what he's about to be asked, having no idea what the substance of these questions are about to be. These interrogations are crucial parts of the investigatory process. The implications are that they are critical, that they can affect a trooper's job, everything from a letter of reprimand to termination, as this commission knows. And so for a trooper to enter that environment and to be the only person in the room who doesn't know what the interrogation is about to focus on, while simultaneously being the only person in that room who has anything to actually lose as a result of that interrogation, the harm is clear from that. And so again, Your Honor, what we're seeking here is a declaratory ruling that any notice similar to this one that does not provide the substance of the factual allegations being made against the trooper does not pass muster and is invalid.
So I want to make sure I understand clearly. So Trooper Woodward is not seeking any remedy other than a declaration in this case. Is that
correct?
Okay. And it's your contention that this is ripe for a decision by us, even though he is not seeking a remedy for himself?
Correct.
And on what basis would you make that argument?
The basis
under the rules, what basis would you make that argument?
Troopers are allowed to appeal violations of the rule that negatively, adversely affect them. This flows directly from that.
All right. And that actually brings me to the other point I was going to raise. There was more than one question that was asked last time we were here. It was not just what did the police know, but I specifically recall asking for some presentation of where the adverse effect is. After we denied the summary disposition, we had further discussions where we pointed out, this doesn't mean that how we're going to rule at the time we have a hearing. Let's hear the evidence of what they knew and where's the adverse effect. I see what they knew. I see nobody presenting any evidence on adverse effect.
Well, again, the adverse effect is clear. This is a process that implicates a trooper's job security. He has a property interest, as you know, in his job. There's a due process that the state police must follow in order to investigate a trooper. Any violation of that process is clearly harming that trooper's rights of due process. This commission made these rules. This is y'all's rule. I didn't just dream this up. This is a rule that y'all promulgated, that you are tasked to enforce.
Last time. We know it's our rule.
I understand. I know I'm probably repeating something you've already heard, but it bears repeating, though, that this is what this commission's been tasked with, protecting a trooper's due process rights. And I want to be clear, we're not challenging the state police's ability to investigate troopers or anything like that, just that those investigations have a clear set of rules that they must follow.
Anybody else have any questions?
Do address Mr. Cameron?
I do want to add one more thing.
Sure, I wasn't trying to cut you off, I'm sorry.
It's also worth asking where's the burden on state police if the commission were to make such a ruling that I'm asking for? The burden would simply be that state police would have to add 1, maybe 2 paragraphs to notices like the one they sent to Trooper Woodward. That's it. This is the bare minimum that we're asking for. We're not asking for some Herculean effort or task for the state police to undertake. We're just asking for them to satisfy the rule as it's written. That's all we're asking for.
Yes.
Yes.
Mr. Wolf?
Commissioners, the request that's being asked for here is a declaratory ruling, not just in this case, but it seems to be expanded to other cases that are not before the commission properly at this time. So if there is any entertainment of a declaratory ruling that the notice was deficient, I would think it would be proper to limit it to this notice that's before the commission. With regards to the argument that the notice was deficient, it listed a DWI arrest that occurred on March 24th, 2021. And in petitioner's own petition, I believe it's in paragraphs 6 and 13, which should already be a part of this record, he outlines specifically issues that could arise from that DWI stop. Specifically, it states he made a DWI arrest on March 24th, 2021. Aside from a minor issue with the intoxilizer on the first attempt to obtain a sample, the arrest was fairly routine. And then in paragraph I believe it's 13. It says, instead of complying with the rule, the LSP seeks to ambush Trooper Woodward, leaving him to guess as to the factual allegations being made against him. For example, does LSP take issue with the basis for the traffic stop, with the manner the traffic stop was initiated, with the manner the traffic stop was conducted, with the initial interaction between Trooper Woodward and the violator, with the manner he performed the standard field sobriety test, with the interactions between Trooper Woodward and the violator during the test, with the manner Trooper Woodward took custody of the violator, with the manner Trooper Woodward transported the violator, with the manner the chemical breath test was administered, with the interactions with the violator during or after the administration of the breath test, with the manner Trooper Woodward affected the arrest of the violator, with Trooper Woodward's reports or paperwork in connection with this arrest, with any other of a myriad of issues related to this DWI arrest. The notice that it relates to the DWI arrest he made on March 4th, 2021 could entail any of those issues. And you don't know what the issues are until you start conducting the investigation and get into the facts of it. Trooper Woodward was not cited with not cooperating with the investigation. He was not disciplined for that. So with your question, Mr. Chairman, is where's the adverse impact? He was able to fully participate in the investigation, otherwise he would have been charged with not cooperating.
I don't know, is one necessary to quote and the other that he'd be charged with not cooperating, even though he could not fully, I don't know that I can draw that logical conclusion, but I am still grasping for some information on the adverse impact.
Smith, there was none. You stated to it that there was no appeal of the discipline, and even a declaratory ruling in this case, there's been no adverse impact, so it wouldn't remedy anything in this case, and I think it would be inappropriate to apply it to any other case that's not before the commission at this time.
Any of the commissioners have questions for the department?
So I have a question.
Commissioner Meredith.
Can we ask, or is it from the court in regards to the notification being sufficient or not? And as far as that in regards to 12.8, contains such information will fully inform the employee of the conduct of which the action is based and which enable him to prepare for defense, including wherever pertinent to date, time, place, and affected by such conduct, etc. Is that Can we ask questions in regards to that, or is the,
That's a
that
different
rule is not
notice.
applicable to this.
okay,
That would come after the investigation of him. If they then chose to proceed with discipline, then you have what is called a pre-disciplinary letter, letting them know that you may discipline him, give him a chance to respond, and then you have a letter of discipline. This is all before that. These are rules concerning the investigations prior to
okay. So
pre-disciplinary.
the actual informing the trooper as far as the violations or potential procedures that he violated, is that in question in regards to the department providing him with enough information?
What's in question is what is required under Rule 12.13, the notice there. That's where the focus is. The 12.8 would come later.
Okay.
And wouldn't we only address that question if we believe that this is an appropriate appeal?
If there was an appeal based on discipline, discipline, yeah.
Thank you. All right, then I'm clear on, thank you.
Anybody else?
One question.
Yes.
Ma'am, just so that I'm clear, you guys were investigating him based on that entire, you guys reviewed, that investigation reviewed that entire DWI arrest, correct?
Yes, if you look at J2, there were a lot of things pointed out that were in question that you don't know what actually occurred until you open and ask your questions and conduct your investigation.
Absolutely, ma'am. And so your notice to him, as I read it, told him just that. We are investigating this DWI arrest, which means everything in its totality, anything that happened from start to finish with that DWI arrest, correct?
Right, and I don't think it's been disputed ever that he only made one DWI arrest that day.
Yes.
Okay.
For some reason, I had in my mind that there were two that day, but there's only one.
Two stops.
He
One
pulled
One
stop.
out.
stop, one DWI
One was
arrest.
speed.
One DWI arrest, correct.
All right, thank you for the clarification.
I would like to point out to the commission that the erosion of a trooper's due process rights is a harm in and of itself. Again, these are sacred constitutional protections that every trooper is entitled to. The erosion of these rights is a harm. And I also want to point out, Ms. Giroir listed all the potential things that he was being investigated for. Well, why didn't the state police include that? They could have easily included a statement, including but not limited to, and then provided the whole slew of things they wanted to investigate. They chose not to when they had all the information in front of them. And again, this wouldn't limit the state police's ability to investigate. Once they're investigating, they can follow the facts wherever they may lead. They're not confined strictly what the notice says. The investigation might start out with what the notice details, but if they start investigating for something connected to that, that's fine. We're not alleging anything about that. We simply say that when a trooper receives a notice, that notice needs to give him enough knowledge to prepare for an interview in which his job security is threatened at that interview based on what he might say there. Again, he's entering this interview. He hasn't had time to jog his memory. He's not sure what they're talking about. He doesn't know exactly what's going on. And the rules don't say that the state police needs to give him a rod and a reel and enough tools to go on a fishing expedition. The rules say they need to provide the substance of the factual allegations being made against the trooper being investigated. Thank you.
Just one thing is with
Real
regard
brief.
to the due process, I'm not sure that these rules rise to the level of a constitutional due process. I'm not aware of anything in the Constitution that says these investigations have to be conducted in this manner. So as far as it being a violation of due process, I'm not sure it rises to a constitutional violation. There's been no evidence that Trooper Woodward was not allowed to prepare for the interview. He, the one DWI arrest, he wrote a report relating to the arrest, so there's been no testimony or evidence that he was not allowed to prepare for the interview.
Thank you. Consider the matter submitted. Commissioner Rickey has made a motion to enter into executive session. Been moved and seconded. Take roll call vote.
Ronnie Crawford,
Yes. Yes.
Robert Meyer,
Yes.
Harold Perry,
Yes.
Sabrina Richardson,
Yes.
Jared Ricky,
Yes.
and Eula Simmons.
Yes.
Just say the
Roll call, please.
Brian Crawford,
Yes.
Leonard Knapp,
Yes.
Robert Meyer,
Yes.
Harold Perry,
Yes.
Sabrina Richardson, Jared Ricky,
Yes.
Eula Simmons.
Yes. At this time, we're back into public session in regards to the motion, in regards to the matter of William R. Woodward, Department of Public Safety and Corrections, Office of State Police, docket number 21251-RB. And I would like to make a motion to deny the request to declare that this notice, the notice contained in this particular case was deficient for lack of substance of the factual allegations being made. Can I have a second?
Second.
Got a motion and a second. Any discussion? All in favor? Any opposed? The ayes have it. Okay, the next item, the rule violation appeals of petitioners Dakota Moss and George Harper, 21-249-RB, with the appeals of their termination, 21-253-T and 21-252-T. Do you have any motions?
I'll move to reject the consolidation. I think it's just, there's too many moving parts and too many reasons this commission, not to create more work for us, but there's too many reasons that we need to hear them all separate.
Is that a motion to deny it without prejudice to their ability to bring it at a later date?
Yes.
Any discussion?
Second.
It was seconded already. All right. Part of the issue involved, obviously, is what we have to take up next, and that's the issue of the stay. There might be different time periods involved with the appropriate stays of the different appeals, and so I speak in favor of the motion to deny the request to consolidate. Any other comments? All in favor of the motion which would deny the consolidation, say aye.
Aye.
Any opposed? The ayes have it. Item number 6 is consideration of motion to stay the appeals of Dakota DeMoss, number 21-253-T, and George Harper, docket number 21-252-T. Do we have a motion?
I'll move to deny the stay.
Well, the motion is to deny. Do we have a second on the motion to deny? Okay. There are ongoing criminal investigations in this matter. I would not support the motion to deny the stay. I think in light of our previous actions and other similar cases where there were criminal matters pending, I'd vote to, I'm opposed to the motion, but I mean, that's just my personal opinion.
Well, explain to me real quick the legal implications, because you know I'm not a lawyer. So I may have made the motion in conflict with what I just moved.
I happen to agree with the motion you made, because, and the reason for that is I think we should be treated, especially if these are allegations involving excessive force, that we should be able to move forward and not, there's a public interest in moving forward with, in a timely fashion with certain matters, especially those dealing with excessive force. I would agree with the idea that we should move forward and with the appeals.
Got a motion, a second, and some discussion. Any other discussion?
Mr. Chairman, restate the motion.
The motion was to deny the request for a stay, as I understand it. Any other discussion? Okay, all in favor of the motion? No, well, Commissioner, Knapp believes that it's appropriate motion, so I think we need to move forward.
Okay.
See where it falls.
There you go.
All in favor of the motion which would deny the request for a stay, say aye.
Aye.
All opposed? No. Ayes have it. Okay, item number 5, commission, whichever comes first, with the exception of SPC Rule 21.21B and D, which will expire as scheduled on September the 30th. And before we have a motion on that, maybe we can get the executive director to.
That was number.
Wait, we skipped 7.
Did I skip 7?
Yes, sir.
Oh, I'm sorry. I didn't mean to skip 7.
I thought you were gonna go back to
Yeah, you have to be at the count.
Well, you got a vice chair.
Number 7, consideration of a motion to ratify the actions of the executive director pursuant to SPC Rule 3.1K in extending authority of Chapter 21 emergency rules until 11:59 p.m. on September 30th, 2021.
I would so move.
Second.
Any discussion? All in favor?
Aye.
Any opposed? The ayes have it. Now, we move to number 8, consideration of a motion to extend the authority for Chapter 21 emergency rules until December 15, 2021, or upon order of the commission, whichever comes first, with the exception of SPC Rules 21.2.1B and D, which will expire as scheduled on September the 30th. Before we have a motion on that, maybe the executive director would like to give a little explanation of this.
Yes, Mr. Chairman, as you know, we've been periodically extending the emergency rules for Chapter 21 due to the circumstances involving the COVID-19 health pandemic. And the summer, our rules deviated from the state police and the state civil service, where they allowed some of their rules, specifically the specialty public health provision, to expire in favor of a different format of their rules. We continued ours through August, which was set to expire. Since we did not have a meeting, I acted with interim authority and extended those till today. In your binders, you'll see a side-by-side representation of our Chapter 21 rules, 21.2.1 specifically, as well as the Civil Service 11.35. And at this time, it should be noted that the state is one employer, and the Department of Public Safety oversees state police service and civil service employees. And at this time, I feel that it's a appropriate time, and I've brought this up to the department, and they do not object, for the rules to realign and the special leave provisions to be similar under both civil service systems, so that the Human Resources Department is operating with one set of policies.
And did you, at the publication of the agenda, did you get any opposition from anyone?
I did not.
All right, we had provided the opportunity for comments at the beginning of the meeting. No one requested comments.
Correct.
Okay, do we have any motions?
I would move that we extend the authority of Chapter 21 emergency rules until December 15th, 2021, or
a second?
Second. I would like second.
Moved and seconded. Any discussion? All in favor?
Aye.
Any opposed? The ayes have it. Okay. Item number 9. Consideration of a motion to go into executive session to conduct annual performance review of the executive director. Have a motion to go into executive session. Moved by Commissioner Crawford, seconded by Commissioner Richardson. Take a roll call vote, and the purpose is to discuss personnel matters, to discuss the annual performance review of the executive director.
Brian Crawford.
Yes.
Leonard Cap.
Yes.
Robert Mears.
Yes.
Harold Fareed. Sabrina Richardson. Jared Rickey.
Yes.
And Eula Simmons.
Yes. See, before we started the last one, I asked where you were, and I just didn't notice this time.
I'm hot if you're ready, Jason.
Sure. Yes, Mr. Chairman, Commissioners, the Director's Report is behind tab 11 in your binders. The first item for the report is the recap for the report for fiscal year 22. That shows the current expenditures for the current fiscal year. Not sure if there's any questions.
Once again, we have no investigative monies.
No, this is what was approved in the legislative session and allotted to us for the current fiscal year. But we will make our request for the next fiscal year cycle. And that budget request will be formulated in October and submitted to the administration and Office of Public Health, Office of Planning and Budget. And I go next week for our training module for the new budget process, which is looking forward to. But I'll keep everyone posted as to that status. And then for our next month's meeting, I'll make sure everyone's aware of where we are with the budget process for fiscal year 23. Any questions about the current budget? Since we met last, we have the final report for fiscal year 21, which shows our expenditures and where we closed out the year. And with we expended $663,000 and we were budgeted $678,000, so we expended a 97.71%. However, if you back out the unspent commissioner per diems and travel expenditures that were unused, in all of the categories, we utilized 98.9% of our fiscal year 21 allocation. Any questions?
Close. It's cutting it close.
Yeah, it's cutting close, very close, that's right. We have a very lean budget, as I remind the budget office when they look to squeeze.
You and staff do an extraordinary job in maintaining the guidelines of the budget and making this your office work.
I appreciate
Thank
that.
you for that.
And the next item is, we'll have the next blue piece of paper in the section 11 is the remaining meeting dates for this calendar year, with notice that the November date has been moved from November 11th to November 9th, a Tuesday, and it will commence at 9 a.m. So those dates are, it was issued via General Circular 222 on September 20th to make that available to the public, the dates for the remainder of the year. And then additionally behind that is proposed General Circular 223, which would be the calendar year 2022 meeting dates. And if there's no objections to the dates there, I will issue that tomorrow or later.
Still the second Thursday.
Still the second Thursday of the month. There doesn't appear to be a holiday overlap this month as there was for next year.
9 a.m. in November.
This year, correct. It'll be 9 a.m. on November 9th. And then the last item I have for the director's report is that the November 21 promotional exam, the first time we're doing the
exam in November. We're offering this exam. The announcement went out on August 24th, and the announcement is open through October 15th, and we're going to hold that exam on November 22nd in Alexandria and Baton Rouge. And we currently have 107 individuals registered to take the November exam. So we're looking forward to seeing how that works, making that offering available to individuals mid-year. And of course, the May 2022 exam will be a mandatory retest. And we'll start the cycle where we're testing in May and November. That's the intention. And that concludes my report. Any questions?
Okay, thank you. Okay, at this point, there's an opportunity to address the commission on that is not on the agenda